Hi, and welcome to Holland Estate and Succession Planning. You're listening to episode 204 of our podcast.
Hi, Suzana.
Hi there, Ian. How are you?
Terrific, thanks. Welcome back.
Thank you very much. It's good to be back.
Yes, it's been a little while, and I know we've had a lot of activity that we've been back and forth on over the last little while. One of the most exciting parts is, of course, that you've been appointed managing partner at Hull & Hull.
Thank you very much.
Which is a great honor, and I'm sure you're going to do a fantastic job managing us.
Oh, thank you, and I'm really looking forward to the challenge.
Yes, it will be a challenge, no doubt. Okay, so first of all, let's just talk about a project that we were working on in the last few months, and that we put together a little bit of a CD. Why don't you tell everyone about that?
For sure. We took an opportunity to pull together what we sort of thought were some of our best podcasts and our best blogs, and we compiled them on a single CD because we've had so many people say, there's a good one on this and there's a good one on that. So we took some of those comments, we put it into a CD format, and so for anyone who's interested in seeing sort of the best of both worlds in terms of our blogs and our podcasts, we'd be happy to provide those to anyone. Just feel free to send us an email at, for myself, spopovic@hollandhull.com.
And actually just send them to Suzana. She'll make sure it happens. So just flip us an email. We're happy to send that along with your contact information. All right, so we have fairly recently come back from a conference that both you and I co-presented at, and it was called the ILCO Conference down in Quebec City, and it's the conference for clerks, and that's their annual conference, and they held it down in Quebec City, and they were nice enough to ask us to speak at it.
Yes, so it was a real privilege to be able to speak to a wonderful crowd.
It was a great time, and we enjoyed both the presentation that we're going to talk a little bit about today and a question and answer period after.
Yes.
So great group of enthusiastic people. Law clerks are a big part of our practice and a big part of the estate's practice, a vital part, and it was nice to be able to have a drink and socialize and chat with some of them.
That's for sure.
So that was Quebec City, and at Quebec City, and we thought we could sort of condense a couple of podcasts into our Quebec City event, because what we did down in Quebec City we were asked to do, and we thought it was a fun thing to have done, and maybe something we can talk a little bit more about in our podcast, was we were asked to talk about settlement and the ADR process. And where we're coming from is this. We talk about it. We've many times talked about family meetings. We've talked about settlement issues and so on. But we thought we would roll our sleeves up a little bit and talk about some of the issues that we concern ourselves at the settlement meeting. So let's just step back for a minute before we start with some of the nuts and bolts of it. And Suzanne, what are we talking about when I say settlement meeting?
Well, we're really talking about the opportunity when you're sort of putting a pause in the litigation and you're bringing everyone with financial interest to the table to see if you can try to settle it. When it's a day that we always say when the law doesn't matter, it's a financial meeting, it's a business day, you're trying to come about with a business solution to put an end to the litigation.
Well, I like that idea of a pause in the litigation, and we in Toronto have mandatory mediation, so we do have a lot of settlement meetings in a formal setting. And so what we're going to talk about today is the more formal mediation, and sort of close the door as though you're watching a mediation, and some of the things that are going on in our heads, both before, during, and after.
Now, not every settlement meeting has to have a mediator involved as well, and so when we're closing this door, we are going to actually have, I'm presuming, a mediator in our room, someone who's a neutral third party who's going to try to facilitate a settlement after he or she has, had an opportunity to explore all the sides of the parties who are involved.
So true. And for these illustration purposes, for this little mini-series in our podcasting, we're going to be working with as though we have a mediator and as though we're the advocates for one side and we're not the neutral facilitator. We'll throw in some jabs maybe at some of the things we'd like to see when we mediate, but let's talk about it from the advocacy standpoint. And even before the mediation, what are some of the things that we do to help get our clients organized and ready for the day? And that's a day that is second to none in importance for some reasons. And so maybe before we talk about what we do, why don't we talk a little bit about why is this day so important?
Well, Ian, as I said earlier, when we're talking about pausing the litigation, once you're into a litigated environment, you know that you're looking at a lot of legal fees, you're looking at a lot of emotional and financial stress that's taking place. And so to be able to get to a point where you've done enough investigation to understand your case or to know the strengths or the weaknesses of your case, you've got enough information from the other side to be able to sort sort of assess their case with some specificity, then at that point you can say, okay, well, let's see if we've done enough of our homework to be able to settle it now, or do we really need someone to make that decision at the end of the day, somebody else, somebody over and above who's not even involved in the litigation.
Right, and can we settle or do we have to have this adjudicated? And the importance is really fundamental to our practice anyway, and that is the truth is 99.9% of the time cases settle. This is a day which is actually designed to focus the parties, and so if you miss this opportunity or you don't use that day well, you've missed a very important opportunity in the process of litigation. Now, you don't always settle that day. You sometimes settle a little before because you've thought about it and talked before, or you settle a little after, or you never settle. But the point is that the importance of that day cannot be underestimated, and we make sure our clients understand that. And little things like we say, dress comfortably. It's going to be a hard-working day. We're going in there, and we're going to roll our sleeves up, and we're going to do our best. So when we're talking to our clients before the mediation, what are some of the things we like to do?
Well, in terms of preparing them, I've seen a strategy that I've adopted in my own practice, and that is to actually have the clients come in a couple days before the mediation and sit them down and talk them through the process. Sit there and explore with them possible settlement parameters, different possible solutions to the problem to see where their head is really at, knowing what we know about our case, because as advocates, I think, when you prepare for a mediation, you prepare for the case at its highest level. And I think that's the very first moment in time when you've sort of dumped all of the information in front of you and you've distilled it and you've assessed your case in a way that you haven't been able to up until that point in time because you have all the information. And so you can do a very reasoned and logical exploration of where it is you think that your case stands in terms of its strength, in terms of its weaknesses, and then you can sort of intertwine that with the client's expectations. The client's got to know that not every case, as good as it is going to be a winner. Not every case, as bad as it is going to necessarily lose. But you've got to manage expectations. And I use that first meeting with them, or first meeting before the mediation, to actually explore what some possible settlement parameters really are.
Well, that's a great idea. And I think the idea of knowing what you're getting yourself into is so important. And often what we'll do is we'll, at that meeting, talk about, well, what is the day? In very basic terms. And why don't we just do that now? Let's just, what are some of the things we'll say to our clients about the day? How's it going to unfold? Well,
as you said, you're coming in, it's a business meeting, you're coming in ready for a long day. I always prepare my clients to not to expect, the normal 9 to 5 kind of thing. No, this is a very intense day from beginning to end. There'll be down periods. I'll explain the role of the mediator, of the fact that normally there's a joint session where everyone's in the room together, but you may find out from your clients that that's not something that's acceptable or something that they're prepared to do. You'd like to explore with them, how it's going to unfold or how you're thinking it's going to unfold, because some mediators have their own processes too, and we can't necessarily predict what they'll expect. But there is a typical way that the day unfolds, and you can explain that to them as part of the preparation process.
And the day itself, it unfolds as simple as this. Usually, is that we go into an open session in a big room, big room with lots of chairs and tables around us, a mediator at the end, us on one side, them on the other. Open session occurs where there's some dialogue either with the mediator or others, the parties starting to set out their positions, maybe adding to their mediation briefs. Our particular format, preferred format, is not to have much discussion then, but hear from the mediator. But that's again, it's a choice of the mediation process. And then we break into caucus. And the caucus session is that one-on-one with the mediator, ourselves, and our clients.
That's right.
And that's the time where the frank discussion gets undertaken. And then it turns into shuttle diplomacy back and forth.
And when you say shuttle diplomacy, I'm just going to pause you there because I have a lot of people say, well, what do you mean by that? And that's a really neat term that we've adopted sort of as a term of art, but the truth is when we say that, what we're talking about is we're talking about this neutral mediator going basically from one camp to another, trying to see if he or she can find a common ground between the respective positions. And so they're going to sort of be the mouthpiece going back and forth to see if he or she can get some kind of resolution that they can put to both parties or all three parties, however many are involved, that everyone can live with at the end of the day.
Apropos to the G20 and G8 that's coming to Toronto here, we call it the Henry Kissinger effect. and at the old 70s idea that Henry Kissinger went back and forth between the Israelis and the Palestinians and tried to broker a deal. That's what this mediator is going to do. And then at the end of the day, we'll refocus, and hopefully if we have a deal, we won't leave the building until we've got it in writing, either either typewritten with a computer there or handwritten. No one leaves the building without it signed, and we typically will ask the mediator to stick around, because right to the end it could be crossing the T or dotting the I, a fight where again that mediator can smooth the edges off a little bit. So that's how the day is going to unfold, and that's the sorts of scenario that we'll often tell our clients. So on our next podcast, let's start to drill down a little bit about the idea that we talk about getting the ducks in order and what that legal concept means, and how we're going to develop our mediation day and our day as advocates at it. So thank you very much for joining us today, and welcome back to Suzana, again, managing partner Suzana. So, and we look forward to our next podcast. Thank you.
Thanks very much, Ian, and thanks to you too.